To this now, News 24 is reporting that the Constitutional Court has dismissed former Public Protector Advocate Busisiwe Mkhwebane's bid for direct access to appeal a ruling denying her the 10 million gratuity she claims she is owed. Chief Justice Mandisa Maya stated that it was a unanimous decision of the court that they found no grounds to justify direct appeal. Advocate Mkhwebane is joining me on the line now. Advocate, good to have you. Thank you very much for your input this afternoon. So it's reported that you would have received a no from the ConCourt as far as gaining direct appeal. What's your response?
I would say good evening, actually good day, Tabo, to your listeners as well and viewers. I would say that the Constitutional Court outcome, which is led by Chief Justice Maya, by declining direct access, doesn't stop us to proceed with the matter. I would like to say we did the application concurrently. We applied for direct access to the Constitutional Court, and thinking that this involves a constitutional institution, where still that the Constitutional Court, there is a precedence of one of the cases of the former COO of the Public Protector, Basani Baloyi, where she was allowed to her matter to be entertained by the Constitutional Court. So unfortunately for me is that, the justice system is not meant to, for me. But then what I would say is that the judge who also delivered the judgment, Judge Moki, we did apply for an appeal. So we are waiting for the date for that appeal so that we can take the matter to the Supreme Court of Appeal.
Yeah, you would have raised the issue of the continuing or at least the worsening suffering as a result of the absent cash. That doesn't seem to have gotten through to the justices. Why?
That's why I'm saying there's laws for Mkhwebane in this country. I mean, I don't possibly deserve to be treated like any other human being. I don't have rights as far as they are concerned. I mean, working as the Public Protector every year, this gratuity, and I think even the misleading information that is 10 million was caused by the mainstream media or those who just perpetrate wrong information. But at the end of the day, that money was set aside for the gratuity, and at the end of the day, it's the interpretation of the relevant prescripts, because it says on vacating the office. It doesn't say how you vacate the office. The way I was badly treated. I mean, look, you'd find any public servant who is dismissed from employment for worst ever crime, but then they would get a percentage of their retirement or, of their pension. Now, with me, that is not happening. So I think the persecution, anyway, is still continuing as far as it relates to any matter relating to Mkhwebane.
This particular quote attributed to Judge Moki, I don't know if you are aware of it. It says it would be absurd for an employer to be expected to pay a gratuity, being a token of appreciation to an employee who left office in disgrace. How do you respond to that kind of comment?
NgesiZulu sithi kobohlama news. One day, the very same judge will be facing what I am facing, and I wonder whether, because the interpretation of the judge's manual, it also mentions various aspects relating to how they are vacating the office. And at the end of the day, it's not an appreciation. As I'm saying that is prescribed in the employment determination of the Public Protector. So treating me the way I am treated, that will face him as well. Because at the end of the day, remember, Thabo, that all the matters which I'm said to have been incompetent on, out of the 400 plus reports I issued, less than 40 of those reports were taken on review. And I mean, look at the judges. You'd find that most of their matters are taken on appeal. They lose them. They up to Constitutional Court. Are they treated the way I'm treated? So hence the judiciary, unfortunately, most of the time is also compromised. Hence, as Mkhonto Wesizwe we are saying, we even need a lifestyle audit of these judges. The board they sit in, the monies they receive to unfortunately find against certain individuals which the system hates. So it's fine. He's setting a precedent because that judgment will come back and haunt him when he or his colleagues are facing the very same judgment, or his children, for that matter, or family.
Do you think the fact that you are now a politician and I suppose earning some money in that capacity could have maybe lightened the case that you were trying to make of suffering because of the gratuity?
You know, Thabo, I'm still suffering a lot. Remember, again, it's the matter of precedence and principle. My matter, it doesn't only apply to me as Advocate Busisiwe Mkhwebane. This, I'm fighting the system on behalf of other Chapter 9 institutions. So it means it's easy then to just treat an employee like this and make sure that they suffer. There's nothing which is lightened on my behalf. I am entitled to that, and I suffered greatly, Thabo. Even now, there's still SARS-related matters. There's still legal costs. You know, I mean, like I'm a matter of Friede, where the judges lied that I changed Madonsela's report. Madonsela goes to the section 194 and say there was no report. And I mean, there are personal costs. You understand what injustice I am facing in this country. Hence, I always say, you know what, I'm treated like a persona non grata in this country because it's like when it comes to my rights, I don't have rights as far as they are concerned.
So you're saying all those legal costs are looking at you, where there's no legal cost that was granted in this particular matter, but you're saying all these other legal battles that you're facing, you're paying that at a personal level?
That's what is happening, and others then we're still fighting them. Remember as well the legal, the attorneys, the advocates, and most of the time some were done pro bono, but then at the end of the day, those are the challenges I'm still facing. And I think possibly they would want to see me, being, what do we call it, not having any other money and possibly sleeping on the streets. Possibly that's where they are going to be excited, because one judge said I must be bankrupted when they were struggling to remove me as public protector. You know, but unfortunately then the ANC and the GNU example was set by removing the public protector. That was the first time they voted together, you know.
So as we see, you're saying, of course, you're pursuing that matter in the Supreme Court, because I think that is the next option that you still have.
Definitely. We did at least put the application on time, because as I'm saying, we put it concurrently, and by doing that, we were making sure that we don't have challenges of now facing the issues of condemnation and all those. So this doesn't mean anything. It just means that they say don't appeal to us directly, but then go back to the judge who delivered the judgment. If they refuse the judge to give us the leave to appeal, then we will go to the Supreme Court of Appeal. So the road is still long. I'm still also giving them the benefit of a doubt, but on the other hand, with the track record of how I'm treated in this country, I won't let it just go away like that. But again, it's setting history and a precedent.
Advocate, appreciate your time. Let's leave you there. Thank you very much for coming on.
So
Advocate Busisiwe Mkhwebane there on the matter of the ConCourt denying her direct access to appeal this matter of her gratuity. The Newsfeed PM continues.